Testing, testing. Good morning. Can you guys hear me? Go out of that one. All right. Let's see what we have here. It didn't even start yet. And I'm gonna have to change this thing. Let's see. Nope. The driver's station I could change. Excitement. Oh, let's see, rejuvenate that. Annual combination. Let's see this. Good morning, everybody. Can you guys hear me? Oh, here go the judge. Oh wait, let me add you here. There you go. Good morning, Judge.
Good morning.
Honey, I do not have my camera on either. You in the dark.
Yeah. It's kind of rainy here.
Oh, it's still raining.
Yeah. Oh boy.
So we just waiting for it to start, basically.
You think she'll show or do you think she'll dodge?
Well, she said she wasn't showing up.
She needs to start acting like she's the DA.
Right.
I mean, that whole thing about her testifying to begin with was you're the DA and you don't get the Fifth Amendment? Boy. Anyway.
Because she could come in and say, I plead a fifth.
Yeah. Except that looks very, very, very bad for the DA to be taking the fifth.
But at least she showed up.
Well, yeah. Sometimes you got to do what you got to do. Fifth is a fifth. But it's just peculiar that the Fifth Amendment would be evoked by the district attorney trying to prosecute the president. You know, that's kind of a weird situation. Last night we were looking at RICO, what it means, racketeering influenced
Mm-hmm.
organizations and criminal enterprise, and she's trying to say it's just going after corporations. Amazing.
Yeah.
See, the whole thing is RICO has got to be set up so that, well, it was passed in 1970. That's 54 years ago. And the purpose was to deal with organizations whose manifest and primary purpose is committing criminal acts. So, going after a rap group, you're trying to say they make their money from crime. Going after the president and his entourage is saying they make their income from crime. going after school teachers and you say they make their income from crime, that's kind of a reach.
Right. Too
This,
much of a reach.
yeah, these folk are the liaisons with the cartels. Yeah, that's RICO. You know, they have extensive gambling rackets that they run illegally, and that's how they make their money. Yeah, they have prostitution and drug rings that they run. Yeah, that's RICO. Anyway, what's coming out of Fulton County looks like the DA's office is engaged in something more arguably organized crime than any of the people they're prosecuting.
Right.
Laundering money to start off with, and a pattern and practice of, shall we say, defrauding the public and misappropriating public funds.
That whole county, and I'm starting to think that whole state is corrupt.
It's the blue one. Blue sort of has this attitude of it's our turn to rip off now.
You think it's a blue state?
Not the whole state, but certain parts of it that are heavily blue. They used to be staunchly Democratic, but in a different sense. The old time Democrats, where Sheriff Bubba Watson, was a Democrat, or Congressman so and so was an old time Dixiecrat. And they still employ the old plantation methodologies. They know they're Negroes, so they can predict them. They know how the Negroes are caught on appearances and are very susceptible to being stuck on stupid. I was astonished the other day. I was listening to or reading a group of black folk were accusing Trump of something that Harris did. Remember when Harris got out, when she first got in and said, we're not going to do anything special for black people? Remember
No.
that?
Mm-hmm.
Well, they were quoting her, but saying Trump said it.
Yeah, he never said that.
No, he didn't. But this group was vociferously yelling, Trump said he'd never do anything for black folk. Why should we support him? I said, well, wow, what you're quoting is Kamala Harris. The ignorance.
And I'm like, they're supposed to start at 10.
They're trying to see if she's going to show.
Well, if she don't show, are they still gonna? Is it gonna go live to say, okay, today's hearing is canceled?
I think they're going to cancel. I think they're going to start on their business. And what she has is only part of it, because I'm sure they've got something other than what she might provide to go on. So I think they're going to start with that if she doesn't show up. And I imagine they're going to make a showpiece out of it without trying to make it look like a showpiece.
You wasting people time, taxpayer dollars.
No, they're conducting their business.
Mm-hmm.
See, they have hearings, and as I'm saying, you may have 15 witnesses, and if a key witness doesn't show up, that doesn't mean you have to neglect the other ones.
John, we on early because we trying to stream the Fani Willis hearing, honey. That's why you don't see me, because I still have morning face. I mean, I got in the shower already and drinking my coffee, but it's early for me. Too early.
We
have a quorum this morning. I will call to order
Okay.
Senate Special Investigative Committee. We have full agenda this morning. We have, first, we need to approve our minutes from the last minute, and then we have subpoenaed Fani Willis to testify. According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr. David Cook, our former Secretary of the Senate, who's been very involved guiding this committee through the process, will give us some insights from his expertise in legislative procedures and the authority for legislative investigations, the rules that govern legislative processes, and these gentlemen will both be available for questions if we may have them as they try to inform us of our legal standing. So I'll wait just a minute, let everybody take a look at the minutes. We actually have two different meetings that we needed to approve the minutes. We lost our quorum last time. I'd want to start with the May 23rd meeting. If anybody just has any questions about that, just take a look and it'll remind you what we've been doing. I was surprised to see in the press that this is our 6th meeting of the committee. It seems like they're moving pretty quickly as we've been in action since back during the legislative session. I expect we will have 2 or 3 more meetings this fall, and we are continuing to get information from members of the public that have concerns and questions and proposed testimony. So we'll have plenty to do as we complete our mission of investigating some of the alleged misconduct and also ways to improve our statutory authority and laws that govern some of the areas that we've heard testimony on. Everything from special grand juries to special prosecutors to funding aspects of district attorneys' offices and accountability for the expenditure of public funds. Those type of things we'll all look at before we come up with final recommendations of the committee. Having reviewed these minutes, is there a motion to approve the minutes from the May 23rd meeting?
Mr. Chairman,
Yes.
I wanted to just make a comment.
Hang on one second.
I was not
Mr.
present.
Leader.
Okay. I was not present physically at the meetings, but I did participate online. There was not a Zoom function, but I listened to it. And so since questions weren't asked, I feel like I wanted to make that be put on the record. But with that being said, I would make a motion to approve the minutes as presented.
Was there one particular thing about the May 23rd meetings you had a question with?
No, sir, no.
All right,
It's not
Oh,
being
let me
asked.
turn this down a little bit. I want to ask, so
Good
what the
job.
hell?
That's
So
all.
she's not
I
showing up.
appreciate you participating.
They don't know.
Bye.
She said if she comes,
online
she's
with us, I
welcome. They
recognize
said
we've
they
got
heard
very
from
busy
the press,
schedules
but
and
they don't have
lots of
any
travel in
official
the
word
off-season,
from her.
so we're trying to
Also
announce
notice
these
the
as far in
accuracy
advance as
and
we can. A couple
continuity
of
they're trying to set up by the introduction of the minutes, which were transcribed as to what was supposed to have happened at the last meeting. So the minutes have to be introduced, approved by someone making a motion to approve them. And if it's seconded, they'll go ahead and keep going.
that particular meeting on May 23rd, we started at, we were planning to start at 2 in the afternoon.
So should I keep playing?
Yeah, keep playing. This is
Your
education.
efforts. Yes, sir. All right.
They're
Any
gonna
other
remember
discussion?
they're going into what the DA's offices are doing in general, this one in particular, about use of public funds, how they conduct their business, meaning the DA's offices. And this is something that is much needed to make sure that the DA's offices do not abuse their authority.
Oh, okay.
And that leads right into that they abuse their authority by
We have
getting
a motion
political
approved. Is
to
there a
oppress
second?
the Trump campaign activities.
Okay.
And then they probably will have something about why did our
All right, they are unanimously approved.
Fulton County District Attorney
We
go
are,
have a trip to Washington,
also joined
D.C.
today by
and meet in the White House
Mr.
with
Joshua
other
Alfonte, who is legal counsel, has
prosecutorial
been retained by
entities,
the
all
state,
aiming at the
to
same
represent our
individual
interests
that, by
in
the
the
way, is probably the party head for a lot of the people on this committee.
enforcement of subpoenas
Not all,
for this
but
committee. I will
within
expect
them.
that at the conclusion of the public portions of this meeting and the public testimony, we may go into executive session to have him, under our attorney-client privilege, advise us as to the current status of any pending litigation. All right, at this time, then I want to have Mr. Stuart Morelli introduce himself and just give us an update on the sort of the legislative process here, the investigative powers of our branch of government, and the ability to have witnesses to testify under oath, and our issuance of subpoenas. As a member of the Legislative Council's office, you're assigned to this committee, and we appreciate your efforts in helping us behind the scenes be prepared and follow the appropriate procedures up until this date. And you shared with me this memo that was really, it's 13 or 14 pages long, that was prepared some years ago by your office. If you would just kind of give us a general overview of the research and work that you've done, and the big scope of things, the legislative investigative powers.
Yes, sir. So, as the chairman said, I believe each of you have a copy of the 2016. I've always called it a manual, whether you call it a manual or a memo. It is the research our office conducted some 8 years ago in outlining the legislative investigative powers, including the abilities to issue subpoenas and compel witnesses to attend. When you're looking through that, you'll notice that a number of citations go back to, of course, Mason's Manual on Legislative Procedures, which I may also be, referencing, in my presentation today. Mason's does a very good job of, outlining the various the powers of legislative bodies, as well as the procedures in them, and cites to, case law in states to support its positions. So as a general matter, it has been found almost universally by the various courts that have looked at the matter, including the United States Supreme Court and Supreme Courts in our sister states, that all legislative bodies have an inherent power to conduct investigations. As the Supreme Court reaffirmed, the United States Supreme Court reaffirmed in 2020, that power is inherent to the legislative process, as in it does not have to arise from a specific grant of statutory or constitutional authority.
This 2020 case would not have been in the 2016.
No, sir. And I'm going to provide some, that information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927 case in McGann. The Mazars case then went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently. As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations, going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I am aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided, but no other justices joined in that opinion. other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature. I will.
Was that an 8-1 decision then? Or?
Justice Alito dissented on different grounds. He did not join Justice Thomas's dissent, so it was 7-2.
Okay.
And just for the record, the Georgia Supreme Court has never addressed legislative investigations. It just has not been an issue that has made its way to the Georgia Supreme Court. So it does appear that there is virtually no case law directly on the ability of the General Assembly to carry out or to compel testimony and compel witnesses to appear before it and to produce documents. In addition to the near universal finding that legislative bodies have an inherent power, it has also been the near universal finding of the U.S. Supreme Court and other state Supreme Courts that the power to investigate is not only possessed by the entire legislative body, but also by its constituent chambers, and that those powers can be exercised by one chamber on their own. So bicameralism has never been found to be necessary to carry out an investigation, to compel testimony for a full chamber of a legislative body. And also, the courts have universally, when the issue has come before them, held that a legislative chamber is fully within its right to delegate its legislative investigative powers to a committee, including the power to compel testimony and subpoena documents. However, the case law is also clear that absent such an affirmative delegation, a committee does not on its own have any inherent power to conduct investigations. And the investigatory powers of a committee are limited to those that are specifically granted to it by its parent body. One area in which there is not a universal holding when it comes to legislative investigative powers would come to the ability of a legislative body or a committee of a legislative body to conduct its hearings and to compel testimony once the legislative body has adjourned sine die. There is a conflict between the state courts that have interpreted this matter. Some state courts find that it is perfectly fine for a subcommittee or for a committee to compel testimony after the parent body has adjourned sine die. Some Supreme Courts have found that it would require a joint resolution of both chambers of a legislative body to allow that to happen, finding that once the General Assembly had adjourned sine die, there wouldn't need to be. It does appear that those committees did carry out their powers once the General Assembly adjourned sine die. I would say the clearest example of this authority comes from 1871 with joint resolutions 7, 9, and 12 of the General Assembly. Both of those, again, were adopted by both the House and the Senate. They established various joint committees to investigate the issues arising of former Governor Rufus Bullock's administration. These resolutions specifically granted to those investigative committees the power to compel witnesses and subpoena documents. Then in 1896, the House of Representatives, and through a resolution, established a committee to investigate each department of the state government. The resolution was adopted on the day that the General Assembly adjourned sine die, so there was no way that committee could have carried out its functions during the session. Based upon the House journals, it does appear that committee did conduct extensive investigations in the interim in 1896. In 1897, the committee filed its report with the House, and the committee report and the minority report go on for about 86 pages. They provide a very in-depth, detailed examination of the affairs and operations of the various state departments. This committee apparently went to the offices of each state executive officer inspected their books, investigated their practices. There is a in-depth discussion of the ability of the affairs of the Department of Agriculture at the time. It appears that the committee questioned the best practices the Department of Agriculture was carrying, not only in bookkeeping, but in contracting with various contractors. I believe it was to provide tags for seed oil. Not being an agricultural guy, I don't completely understand that. They also, there are references in the committee report to how they visited each of the state's hospitals at the time, commenting on even when they went to the school for the blind, that the dormitory for one set of students, the boiler room was lacking adequate insulation around the boilers. So it was a very in-depth review, digging into the details and operations of the various departments of the state executive branch. And again, making comments on their bookkeeping, making statements on how much funds they had. The committee made a number of recommendations, both for potential legislation to address matters that they saw, as well as to recommendations on future appropriations, whether to increase or decrease the set levels that had been given to the various state agencies. I will note that the 1896 resolution by the House does not state that it grants the committee the power to compel witnesses, but as I said, they undertook an extensive investigation. The report makes no indication of whether or not the executive branch objected. So I cannot speak to whether or not they were forced in some manner to get the executive to comply, but the report is silent as to that matter. And then finally, at least in the past 100 years, we're getting up to, in the 1964 special session, the Senate adopted Senate Resolution 30, which established an interim committee to make a comprehensive inquiry into the Stone Mountain Memorial Association. I just discovered this resolution last night and was unable to get my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial Association also was silent as to whether or not it delegated the power to compel witnesses. I was able to see that a number of bills were proposed and adopted in the 1965 General Assembly, revising various provisions of the law governing the Stone Mountain Association. So I would make the assumption that the committee did make some recommendations that led to that legislation. Enforcement of legislative subpoenas has also been a matter that the courts have been forced to address throughout the history of the United States. Going back to 1821, the United States Supreme Court in the Anderson v. Dunn case did find that each House of Congress did have the inherent power of contempt. In that case was actually a case where a gentleman was detained by the Sergeant of Arms of the House, and he had sued under habeas corpus to get his release. And the Supreme Court did uphold the finding, the Federal House of Representatives finding of contempt, the power to find him in contempt for refusing to come testify before them. In addition to the inherent power of contempt that most courts have found that legislative bodies have, judicial enforcement of subpoenas has kind of been the more modern practice if a state has not adopted a specific statutory procedure for enforcing its subpoenas. There are some states, like New Jersey, for example, has a very detailed provision for the enforcement of legislative subpoenas that ultimately can result in a person being held in criminal contempt if they fail to abide by a subpoena. In Georgia, we do have a couple of statutes on the books that do provide some degree of guidance for judicial enforcement of legislative subpoenas. One that I will not spend a lot of time addressing, nor does the manual, are the provisions in Title 28 regarding the House and Senate ethics committees. Those are really much more designed to carry out ethics investigations into members of the General Assembly themselves. of course, we can get into that if anyone wants, but they are not, those provisions don't seem particularly pertinent to the present committee. In addition to those provisions, there are the provisions of OCGA 48-15-17 and 45-15-17 and 45-15-19. OCGA 45-15-17 provides the authority to the Attorney General to conduct investigations into the affairs of the state, and does now provide procedures by which the Attorney General can compel people to appear before his or her investigations, subpoenaing those witnesses and subpoenaing documents as part of those investigations. In the event that the Attorney General is forced to enforce, if somebody refuses to comply with one of the Attorney General's subpoenas, the code provides that the Attorney General has the ability to go to the Superior Court of the county where the person to whom the subpoena was directed resides to seek judicial enforcement. OCGA 48-15-19 grants
That's what
both
I
the
was
governor
saying
and the
last
General
night
Assembly
about
the
they
exact same authorities that
a
are granted
local
to the Attorney
circuit
General
court or
in
court with the
48-15-19.
jurisdiction and apply for enforcement.
While these statutory provisions do
There
exist
might
both
be a
in
conflict
48-15,
with
both in
Fulton
Title
County
45 and in
in
Title
so much
19,
as
we
we've
don't
already had several
override the
recused
General Assembly's
themselves,
inherent
judges there,
authority to
3,
conduct investigations or its
and
inherent
it would
authority
be reassigned
to
to
carry
another
out
court,
contempt
which would
procedures,
probably
or
be
its
a
inherent
lot worse
authority to
for
attempt
her.
to enforce its
Can you hear me?
subpoenas. Article 3,
Yes, I can
Section
hear you.
6, Paragraph
Okay.
2-3
I lowered it down
of
when
the
you were
state
talking.
constitution
So
provides that the
That
General
was an
Assembly shall not
explanation
abridge
to
its
the
powers
people as
under
to
this
what's going
constitution.
on.
No law enacted by the General Assembly shall be construed to limit its powers. Therefore, the provisions of Title 45 and Title 28 are not limitations
The
upon the General Assembly's
legislative body,
power. They are
the
additions to
proper
its inherent power.
in and jump in the water. They lay careful preparations, which is what's going on here. In the record, which will be open for court review at a later point, or by the citizens of the state, they're carefully explaining what, why, and how they're doing what they're doing, which is good practice.
also, I have a question here for you. It says, this is by Guatemala Kid. Are you familiar with the Law of War Manual and what entity has the power to, under certain specific circumstance, investigate and prosecute a rogue capture federal government?
Well, there really is none such, but there are some agreements and protocols between some of the major nations that agree to do these things. The Hague Convention at the turn of the 20th century, for example, various treaties with the UN that have been entered into. There are some things, for example, that are 100, 120 years old in terms of treaties that the U.S. has never entered into formally, but honors because Article 1, Section 8 says to the government has an obligation to enforce the law of nations. That's a quote.
Mm-hmm.
And that gets taken that way. So some of these things are just protocols that have been established over the last 100, 150 years to make war less savage, if you can imagine such a thing.
Real quick, Keith, don't come over here with that nonsense. He was not pooping. He was not in the bathroom. What are you talking about?
No, I'm not in the bathroom.
No, they saw your leg, so they thinking that you were like in the bathroom. Like, he has on shorts and he was in the pantry of his house. Somebody says, does Georgia State hold higher status than SCOTUS?
No, it does not.
Okay. All right, I'm gonna turn the volume back up.
Hannah Supreme Court. And I can give you all the citation for that case if you give me a second. Sorry. There we go. McLaughlin v. Montana State Legislature. In that case, the Montana legislature had subpoenaed the court administrator to request all emails that the court administrator had with the various judges of the Montana judicial branch to investigate whether apparently the Montana legislature had been considering some legislation regarding, I think, judicial compensation or some such. The judges circulated a poll amongst themselves, and the legislature was interested in the results of that poll. Ultimately, the Attorney General of Montana, challenged legislative subpoenas, and the Montana Supreme Court did find that separation of powers in that case did require, and citing favorably to the Mazars case, that the legislature had exceeded its authority. Ultimately, the Montana Supreme Court found that Montana, similar to Georgia, has a procedure for judicial punishment, and that the alleged purpose of the subpoena was to investigate whether or not the judges had complied with the Open Records Act, and the Montana Supreme Court determined that that was not a function of the legislature, since there was an established procedure for the punishment of judges. The Montana Supreme Court found that the resolution setting out, or the subpoena issued by, it was, I believe, the Standing Judicial Committee of the State Senate there, did not properly detail a legislative purpose beyond seeking to see if the judges had complied with their Open Records Act. The other state appellate court that has addressed the Mazars case would be the Commonwealth Court of Pennsylvania, which I believe is their intermediate appeals court. The Pennsylvania Commonwealth Court in Costa v. Ward found that Mazars was not applicable to an issue arising when the Assistant Secretary of State of Pennsylvania attempted to quash subpoenas issued by their state Senate. The Costa Court, the Pennsylvania court, did find that the Mazars case was limited in scope to the specific unique role that the president has in the federal system. However, we also have a Georgia case, which is not directly on point, but it does address the issue of separation of powers when it comes to governmental investigations. In 1975, the Supreme Court issued an opinion in Dean v. Fulton. In the Dean case, the lieutenant governor had requested the governor to request the attorney general to conduct an investigation into the travel and expense accounts of a state senator. That investigation was,
by the way, what you're listening to,
previous version,
what a lot of people
OCGA
on
48,
social
15,
media
17,
do not understand about citing authority. They want a citation to back up someone's assertion of facts, which is no more reliable than any other one person writing something. So they're saying, I accept the factual representations of someone I never met, never heard from, because they wrote it down over what somebody that is speaking or directly publishing in response to something that I am saying or interested in. What they are citing is authority based on rationalizations of things, logic and reasoning. That's what these processes are about. When you cite these cases, what did they discuss in them, and how do those discussions apply to the instant situation?
Thank you, Teflon Don, for the super chat. Hello, Judge Brown and Dana. Hope you guys are having a fantastic one. Thank you so much. Same to you.
Resolution forming this committee?
Yes, sir.
Or their predecessors?
Yes, sir.
would you give me the citation to that case?
Yes, sir.
again?
I'm sorry.
called Dean versus Bolton.
I'm being a bad attorney and not giving you the sites.
You got a whole bunch of attorneys on here. You got a couple of non-attorneys that are as smart as.
And I can provide copies of any and all of these.
It's another question, Judge. What rights or authority does Miss Fanny have in regards of this?
Georgia.
I see those posts. Basically, none. She has to go to court to try and quash the subpoena. And if the subpoena has been issued pursuant to the business of the committee or the legislative body, she's going to have to comply. Otherwise, she'll be held in contempt until she does, either by fines being assessed, which are interesting, or actually jail time. You have a situation with the rap artist that's similar. You recall the judge demanding that the attorney for one of the defendants comply with his order to reveal who gave him the information that an ex parte hearing had been held with a witness without advising defense. So Fanny is still an officer of the court, even though she is an elected official. She is representing the people, but she's still acting as an attorney before a court, or in this case, subject to the subpoena powers of the state legislative body, which can, as you just heard read, and I discussed with you last night, can result in a court of competent jurisdiction enforcing the subpoena.
So another person champions, Miss Dana, will you and the judge give insights from the trial of those Memphis cop killers of Terry Nichols? Is that going on? Of course.
Well, when it starts, the main problem with that is that the lawyer who filed the lawsuit filed it on behalf of someone who arguably under Tennessee law has absolutely no standing to bring the lawsuit. There is a situation with the Tyree Nichols situation. Well, there is a situation with the Tyree Nichols case. Let me not use that word twice in the same sentence. And it's this: under Tennessee law, if a parent puts a child up for adoption, they lose all parental rights. And the parental rights pass to anyone who adopts the child. So Tyree Nichols was adopted by a white couple out in California. And the plaintiff in the case in front of the Tennessee civil courts has been filed by someone that arguably has absolutely no standing, because they were stripped of their parental rights when they put their child up for adoption.
All right.
As far as
we don't need a recap of the whole case.
No, I'm not, but I'm just saying that's what's going on right now. That has to be resolved, and the civil matter is on hold pending the outcome of the criminal case.
All right. Well, no, they just want to know we're going to talk about it. And I say, yeah.
Some pled guilty, and the rest of the matters are pending. So that hasn't
been taken as authoritative precedent. But, as I, said when my discussion about the Pennsylvania court did not accept Mazars as binding precedent, whereas even the Montana Supreme Court, when the state Senate asked for a motion on rehearing, the Montana Supreme Court in their petition to deny rehearing did state that they were citing Mazars only as authoritative precedent, but in no way claiming that it was binding precedent upon the state of Montana.
So when we talk about the idea of legislative oversight, legislative investigations on the federal level, there's a line of Supreme Court cases that say this is an implicit or inherent power of the legislative branch, that you have the power in order to do your job of passing laws in the public interest, creating public policy. You occasionally have to investigate. Similar to when our committees meet during session, we routinely have hearings and have presentations by the author of a bill and any other interested citizens giving pros and cons of the bill, right? And that's necessary for the legislature to do this investigation, to do their legislative duties.
Yeah, yes, sir. The general view is that the investigative power has to be inherent to the legislative process because, again, as the Supreme Court recited in the Mazars case, without information, a legislative body cannot properly legislate, as I believe the U.S. Supreme Court said they'd be legislating in the dark.
Very similar to probably the seminal United States Supreme case creating judicial review, Marbury versus Madison. I have all the lawyers on this panel, they graduated law school, so they know that one. The United States Constitution never says the United States Supreme Court has the power to strike down a law as being unconstitutional. But
Correct.
they stated that power because it was implicit, inherent. Otherwise, you're a ineffective branch of government as the judicial branch if you don't have that inherent power to set the rules, what is and is not constitutional, right?
Yes, sir.
Same type of principle here on legislative investigations, that is an inherent legislative authority, whether the U.S. Constitution says it or not.
Yes, sir. And
But the Supreme Court, it says they got it,
yes, sir.
even though it's not articulated in the Constitution.
Yes, sir.
Any reason that should be different at the state level?
No, sir. In fact, some of these, what I've seen in some of these state Supreme Court rulings is they find that inherent authority can also be justified under a separation of powers because absent, the ability of the legislature to investigate on its own, would be highly dependent on information provided to it by the executive.
So even if Georgia's Constitution did not give an investigative power to the legislature, it would be implicit if in keeping with the United States Supreme Court's interpretation of the separation of powers.
Yes, sir. Yes, sir.
And the provision you read out of the Georgia Constitution, does it essentially give us that constitutional authority?
The state constitution does not give an explicit power to it and to conduct investigations. It does specifically authorize the provision I cited specifically gives the General Assembly and its chambers to establish interim committees to conduct, activity once they've adjourned sine die. Since the General Assembly cannot legislate post sine die, really the only activity those committees could take would be studying or investigating.
And that's what we're doing, studying and investigating here. The Dean versus Bolton case was a Georgia Supreme Court that says the legislature does have investigative powers.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations that the legislature has an inherent ability, power, authority to investigate.
Not in so many words, but I would say that your statement is correct.
Okay. And this committee, in our resolution that formed us, and I'm going back to Senate Resolution 465, says at line 81, section 4 here, the chairperson shall call all meetings of the committee. Committee may conduct such meetings at such places and at such times as it may deem necessary or convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of this resolution. That in no way limits the meetings to just during the legislative session, does it?
I do not read any specific limitation.
It's whenever the chairperson calls the meetings and at any places and times as we deem necessary to do our job, right?
Yes, sir.
Okay.
Up through I would say up through when the next General Assembly is sworn in on the second Monday in January 2025.
So to that point, we're no longer in office. The biennial is over.
Yes,
By
sir.
the way,
I'd be in office if we're lucky
means
enough to be
the
reelected and have chosen. to
matter,
run.
the
Otherwise,
business has been adjourned
Yes.
until further notice.
is it your legal opinion?
Wait, what business?
When they say sine die, that means it's been adjourned until further notice. So the legislative body is not in session, even though the committee is. The crucial thing is this business of the committee or of the body, and what they have discussed is that the body has delegated this authority so that the committee can keep working even though the legislature is not in formal session.
In the Constitution, or just
One other
the
thing I might
implicit
make an
inherent
observation
powers
on,
that
the way they're carefully setting this up and getting firmly into the legalities of what is going on, that is indicative of the likelihood that they're about to do somebody in if they don't show up.
that
Fannie Willis.
Yeah. In other words, they're setting the stage to unload on her if she defies them. One other point,
Which
too.
is why they're reading the law.
Yeah, and getting it firmly on the record. One other
Well,
thing,
is she
too.
on trial now?
No, she's not on trial, but they're setting the stage for what they can do. So nobody says, well, how did they do that? Well, they laid it out. You might not have listened, but it's part of the record. The other thing that is inherent in what you're hearing is why term limits have a con side, which is the legislators who are in there and termed out don't ever find this out, or they have to have this kind of thing done over and over again. Whereas if they are in there longer, they have heard this kind of thing and already know it, so they're familiar with it. So anyway, that's the downside to term limits. They get in, and by the time they learn what they're doing, they're termed out.
Oh, okay.
Yes, sir.
Like Congress.
Appear to be an
Yeah.
explicit delegation of the Senate's inherent powers to this committee.
is this in any way inconsistent with any statutory authority in Georgia or constitutional provisions in Georgia?
They're
It
letting
is
out a
not
careful
contrary to any
case.
constitutional provision, and because it is the inherent power of the body arising from the Constitution, I don't believe
This
a
is
statutory
to
provision
defeat the
could
politics
conflict with it.
of her getting up on another
The
pimp
resolution
preacher
goes on
pulpit
last
complaining
page
about their dumping
before
on her
issues
because
such
she's a
inherent
sister
powers.
girl.
Code sections 45, 15, 17, and 45, 15, 19 empower the General Assembly to make investigations into the affairs of the state and further authorize compelling the appearance and testimony of witnesses and the production of records, and grants the power to place witnesses under oath or affirmation and to enforce subpoenas issued pursuant hereto. Is this just an additional power to subpoena?
Yes, sir.
Okay, and that's what's contained in those two statutes?
Yes, sir.
Okay. Tell us about those two statutes.
Yes, sir. Again, 45, 15, 17 is the statute that grants investigative powers to the Attorney General that I talked about earlier, including the ability to subpoena witnesses and to compel the production of documents. It also does provide the procedures for enforcing those subpoenas, whereby if a person refuses to comply with the subpoena issued by the Attorney General is empowered to seek judicial enforcement of those subpoenas by going to the Superior Court of the county of the residency of the subject of the person to whom the subpoena was directed.
And does that statute give the legislative branch the same powers and authorities as the Attorney General?
OCGA 45, 15, 19 gives the General Assembly the same powers that the Attorney General has in 45, 15, 17.
So those powers of the Attorney General to subpoena and compel testimony or documents is granted to the General Assembly in 45. You got that.
15, 19.
15, 19.
Yes.
Okay. And that's recited in our resolution that formed this committee, that we possess those powers.
Yes, sir.
In addition to the power granted through the resolution itself, and in addition to our inherent constitutional powers. To
Yes,
do
sir.
so. Okay. Do you have any question that this committee has the power to subpoena testimony or subpoena documents in furtherance of the duties set forth to this committee in the resolution 465?
No, sir.
Any other senators have questions? I want to recognize the minority party as our rules provide to ask any questions. And Senator Jones, I'll look to you since you've done that. Since this is more of a presentation than sworn testimony, since he's counsel for our committee, I'm going to defer to you. But then if other committee members have specific questions, unless there are objections, we'll do that.
Right.
You have the floor.
I
Let's
just
make
have
sure
one.
you're lit up. All right.
And that was the 4 instances that you gave about them. I guess the committee doing an investigation after sign or die. Can you kind of go back into that a little bit more? And it was the last time that happened was in 1964. Is that correct?
Yes, sir. The last time that I'm aware of a committee being created, a committee being created specifically to investigate a specific part of the state government was the 1964 resolution that the Senate did regarding the Stone Mountain Association.
And obviously no one has never come up. So this would be a case of first impression, I guess.
Yes, sir.
If it goes to court. Have anyone given any legal opinion about why they may believe that they are not subject to subpoena? Like, what's the counter argument? I'm just curious.
My understand, they're people who have court, like in the Montana case, the court administrator did argue that the subpoena went beyond a legislative purpose. There are limitations that a legislative subpoena must be in furtherance of a legislative purpose, and so there are many instances where people have challenged a subpoena issued by a legislative body, alleging that there is no legislative purpose behind this investigation.
And do you think that would apply in this case? Of course, we don't really know, do we?
The resolution, under my understanding of the resolution, is that it is designed for this committee to investigate potential legislation to be introduced regarding potential matters of appropriations regarding district attorneys, the contracting procedures, especially in regards, I think it specifically references hiring special prosecutors. So my understanding of the resolution is it does outline a legislative purpose for the committee.
Yeah, I think so. Thank you. That's all.
And doesn't it specifically direct us to investigate the conduct of District Attorney Willis's alleged conduct?
Yes, sir.
So it wouldn't be out of line to invite or to compel her to appear for this committee then, would it?
Not if this committee believes that is in furtherance of its legislative purposes.
Seems it's almost fair to give her a chance to defend herself and give her side of the story. Agreed or not?
I have no position on that, sir.
That's the lawyer answer. That's good. And that's what we pay y'all the big bucks for, is just give us impartial advice. Thank you. Other committee members with questions? Senator Tillery, I'll recognize you.
Thank you, Mr. Chairman. Thank you, Mr. Morelli. I have one question. I heard you read the Dean opinion that talked about let it be sufficient to say the constitutional provision does not prohibit a person from the executive branch from investigating, or from the legislative branch from investigating. Then I want to go to that next paragraph though, because you've studied this more than we ever will. The sentence that said the General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. In your research, I understand where you've tied this up, but I want to look at the little hole here and say, have you in your research found any statutes or procedures that the General Assembly, since this decision, have enacted that would limit that power that you discussed that Dean appears to give?
Yes, sir. Actually, following the issuance of Dean, or almost concurrent potentially, the predecessor to OCGA 45-15-17 was amended in 1975. And one of the provisions added at that time, and I'm going to pull that was a subsection D to OCGA 48-15-17, which specifically provides that nothing within that code section shall authorize the Attorney General to investigate members of the General Assembly during session.
During session.
Yes, sir.
So if we carried that same provision over to 4518, or sorry, 481519, then
That statutory provision, of course, could not, but the Constitution does grant each chamber of the General Assembly the ability to, govern and investigate, there's an inherent and constitutional power of each chamber to govern the conduct of its members.
gotcha. So that whole would not be able to eviscerate the power that it appears that we have through the Constitution and then through the progeny of Dean.
Correct.
Gotcha.
And further backed up by the provisions of the ethics provisions of Title 28, which were subsequently added much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure for the ethics committees to issue subpoenas.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA
Thank you, sir.
55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law in, I do have that before me if you will give me a second. It was in the 1950s. I do know that much. I don't, I want to say 57. I don't know who the governor was.
Any stories behind the reason for the laws at the time?
My research did not delve that far. I've saw the statutes are on the books, and in preparing for today's meeting, I went and pulled when they were initially enacted,
Okay.
but I did not do any further research on what may have created them,
Thank you.
caused them.
All right, I would advise all committee members that Mr. Morelli is available to all of us if you want him to follow up with any further cases or explanation or updates. You're all free to contact him directly. He is assigned to this committee as a resource to each committee member. The memorandum, I call it, they call it the manual on investigations and subpoenas was done back in 2016. We each have a copy of that in our folders, and it sounds like he's done some updated research. I just have one more question. We need to move on. That Supreme Court case, is it Mazars that you're saying?
Mazars.
Mazars. Is that one where the president was objecting to subpoenas from some congressional committee?
Yes, sir. A variety, I believe multiple committees of, I think it was the House. That was the case where they attempted to get his bank records. Mazars USA was one of the accounting firms, I believe, that personally worked for President Trump and his businesses. One of multiple, I believe, House committees attempted to obtain documents from them. Trump
So they objected to the
President Trump objected to his bankers releasing the documents. So
did the Supreme Court force them to produce the documents in
the Supreme Court overturned it, both that I believe there were cases both before the U.S. District Court for the District of Columbia and some in the Southern District of New York. Both of those trial court levels did go up to the relevant courts of appeal. Both the DC Circuit and I believe the Second Circuit upheld the subpoenas. The cases were merged before the U.S. Supreme Court, and the Supreme Court found that both the various courts of appeals and district courts didn't consider separation of powers issues relating to the president, remanded the matters back. I believe ultimately the various trial courts and courts of appeals allowed the committees to get some documents, but not as many as they had initially been seeking.
Yeah, and so the limitations on those subpoenas were due to the presidency, not other government agencies.
It was based upon the finding that a legislative subpoena on the president's personal documents so interfered with with the entirety of the federal executive branch, because under the unitary executive theory, the president is the executive branch.
So is this when they were trying to get his tax returns?
So what are they talking about now, Judge? Are you there?
Those are based on stuff.
So this
This is when they were getting Trump's tax returns when he was in office about 6-7 years ago. He was trying to do that.
All right.
So what they're talking about is the reason that there were some restrictions that the court did put on what the subpoenas could see was because of the unity of the executive branch. The president is the executive branch, and all of the rest of the people involved in it are his subordinates. In other words,
why hasn't Fani showed up with her attorney?
well, that's what they're laying out here. In other words, if she fails to show before they finish up their session, I think she's in trouble. And they already indicated we welcome her if she does indeed show whenever she shows. So I'm sure that got communicated to her, and it doesn't really make any difference if it didn't.
Right, because she got the damn subpoena. Okay.
And she's in defiance, which, by the way, becomes an article.
Taking a break now.
You want me? I mean,
No,
the chairman has dismissed me, but
you're not dismissed. You're just taken off the hot seat. If you want to sit up there, you're welcome to, because you guys are both just full of knowledge. That's good for us.
I'm going to go back to my preferred spot, hiding in the corner.
All righty. We do. We do. You'll raise your right hand. I'm going to swear you in before the committee. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. Please state your name, your previous position, and tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I am received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977, in front of the Senate for a contempt proceeding. So I was kind of chuckling when that case came up. But I've been associated with the Senate in one way or another for a number of years. I was Secretary of the Senate for the last 11 years and retired at the end of last month.
By the way, at the date he's
In your
talking
role,
about,
you
I
have been
was
a
chief
great
public
guide to the
defender for the
Senate
city
and
of Memphis and had been a prosecutor.
Have had procedural questions and issues, and you've been a great help to me, providing me just binders full of information, especially on how investigations have been conducted by legislative branch at all levels of government. So I wanted you as sort of a subject matter expert to tell us your thoughts today. Just give us your preliminary reviews and talk to us about the power to investigate of the legislative bodies, the Senate in particular.
Good. Well, thank you. I think the question before the committee obviously is, does the committee have the authority to investigate, to subpoena witnesses, and to compel production of that testimony or of documents? And I am of the opinion that the Senate clearly, and that this committee clearly has that authority. I'm in agreement with counsel who just testified here. I think he did a good job of laying out the law regarding the power to investigate. I want to come at it more from a parliamentary law, parliamentary procedure standpoint, but there's no way to separate those two out. They are both intermingled. So Stuart may have some comments on what I may say, or I'm going to provide some of my understanding of what I think the law says. But I'd like to start to basically give you what I think is an analysis from the viewpoint of parliamentary law and procedure as to why this committee does have the authority to do the investigation, to subpoena witnesses, and to enforce those subpoenas. I would first touch on a few principles of parliamentary law and then move on to our rules of procedure, parliamentary authority that has been adopted by the Senate, and hopefully demonstrate that this committee was one properly created, that the subject matter of the investigation is legitimate, that the committee has the power to meet during the interim, which we talked about a little bit, that the committee has the power to subpoena the testimony of government officials and to enforce those subpoenas. So before I begin on the parliamentary path, I think it's fundamental that we tip the hat to the 100 or more years of U.S. Supreme Court case law that says a legislative body has the power to investigate. I don't really know of any court that has said a legislative body does not have the power to investigate. There are some differences when you get down into other issues as, do you have the power to subpoena? Do you have the power to compel that? And I think the contempt power of the Senate, for example, provides some limitations, but there are other avenues to enforce subpoenas as well. So I think the analysis Stuart gave regarding the inherent powers of the Senate is very important. It's what most everything that we're talking about today is based on. Mason's manual, which you referred to a little bit, is recognized as the modern day parliamentary procedure manual for state legislators and legislatures, and is for the Georgia Senate. It's actually interesting. There have been 3 iterations of this manual. The very first one was by Thomas Jefferson when the country was instituted, called Jefferson's Manual. And out of that arose Cushing's Manual, which was used in the 1850s. And in the early 1900s, the state of California, Paul Mason, developed a very robust manual of legislative procedure, and it evolved into what we have today as Mason's Manual of Legislative Procedure. It's the authoritative manual on parliamentary procedure for state legislatures.
Is this the one that the National Conference of State Legislatures has adopted?
That's correct.
Yeah.
California granted NCSL, National Conference of State Legislatures, the actual rights to this in the 1980s. And since then, NCSL, they have a committee of parliamentarians that sit on this, and they update it every decade. So the most recent edition is the one that was updated in 2020.
Tell the committee and the public that's listening to you what NCSL stands for, what that organization is.
NCSL stands for the National Conference of State Legislatures, and it is a national association that is comprised of, to my knowledge, every state legislative body in the United States. And it draws on the expertise of members of the legislature and staff to help the state legislatures perform their functions as legislative bodies.
Well, it just so happens that Senator Kennedy and myself were at their national convention
Right.
this summer.
Mm-hmm.
And there was a session on, I believe it was titled, Everything You Want to Know About Legislative Subpoena Power. 3 different states had presenters, and all unanimously said their states had upheld the power of the legislature to do investigations and use subpoenas. It's funny that that issue happened to be, addressed this year, but it was certainly reaffirming to us that all the states claim this power and exercise, and it's been upheld.
Right.
Back to Mason's.
Yeah. And to my knowledge, there's been the power to investigate is derived from the grant of legislative authority that has been given to the General Assembly by the Georgia Constitution. And everything kind of derives from that legislative power. The interesting thing about Masons, the good thing about it is that when you look at our rules, Senate Rule 10-1.5 provides that when any question that's not provided in our rules, which arises and not provided in these rules, the same shall be controlled by the most current edition of Mason's Manual. So the Georgia Senate has adopted by its own rules everything that's in Mason's Manual. Obviously, there will be a few things that are a little inconsistent and where we are more specific on it. For example, there's some question about whether you can meet during the interim, but we have a Georgia constitutional provision that allows us to do that, which would override Mason's Manual there. So we've adopted Mason's, and we'll be citing that throughout. Both, I think Stuart cited it, and I'll certainly be citing it. Before we get into the substance of the rules, I think it's important to touch on how rules of procedure are applied, and Mason's does a really good job on it right at the beginning of Mason's. In section 4, it puts it pretty succinctly. Mason says that the rules of parliamentary procedure are derived from several sources and take precedence in the order listed below. Those principal sources are, number one, any constitutional provisions. So if you're looking as to how the legislative body should act, constitutional provisions and judicial interpretations are paramount. The next authority are the rules of the Senate that we have adopted. The third authority is, what is our custom? What precedents have we had? How do we normally operate? And we have several ways that we operate that involve precedent and custom. Following that, in the level of authority, are statutory provisions. So in terms of procedure, our Senate rules can trump statutory provisions regarding procedure. Then the adopted parliamentary law, which is Mason's, and then fundamental parliamentary law, which really is pretty succinctly due process requirements that are required for any legislative body, and lawyers are familiar with it, with due process in court, notice and opportunity to be heard, those kind of things. So Mason's is an important part of the Georgia Senate's parliamentary rules. I'd like to take just a minute to talk about committees, because that's what we're talking about here. There are really three types of committees. One are standing committees. They're provided for by our rule, section in Rule 2-1.3. And the purpose of standing committees is to look at issues that we know are going to be continuing. You have public safety, you have judiciary, you have government operations. We know that there are going to be all kinds of issues that occur during the session every year, year after year, that require the establishment of a standing committee to look at those issues. This committee is not a standing committee. The second type of issue, or committee rather, is conference committees, and those committees are created for the specific purpose of resolving differences between the houses. And you all are familiar with those on the last several days of the legislative session, where we have conference committees meet and work out disagreements between the House and Senate. And the third type of committee are called special committees. And special committees are created for the consideration of a specific task or duty, or to look at a specific issue, or to perform a specific function. These committees can also be named ad hoc, investigating, select, or study committees. We refer to them a lot as study committees here. And special committees are created by a resolution, either by resolution, they can be created by a motion from the body. In this particular case, SR 465, the resolution that created this committee was established by a vote of the Senate. Senate Rule 5-5.1 requires 29 votes to establish this committee and pass that resolution, and that occurred in the 2023 session. So the committee was appropriately established as a special committee of the Georgia Senate. So what are the committee powers? So the creation of a committee is authorized, as I said, by a resolution. And I think it's clear, I've kind of refer to Masons here a little bit and quote them. The Masons provides that the legislature may proceed to make investigations with its authority by authorizing committee of one or both houses. So there's been some question of whether the Senate can act without the House, but Masons clearly says that either house can establish a committee for purposes of investigations. Masons also says that the right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. That's Mason's 795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on one of those going back to 1871. I think I'm not familiar with that one, but I am quite familiar with the 1964 Senate resolution that created the Senate Committee to investigate the Stone Mountain Memorial Association's Senate Resolution 30.
You know
was
what?
actually created
They're
during a
getting ready
special
to
session
unload on
of the,
Fani
of the
Willis.
Georgia
They
Senate
are
General
really
Assembly
about to
here, and
jump her if
issued
she
the
does
report
not
back,
show.
I believe in the next year.
Oh, really?
That's
So
why they're spending so much time laying this out. They are dotting all the I's, crossing all the T's. You notice they've gone back more than 150 years, citing their precedent. They even went back to Thomas Jefferson,
the creating body that
and they're going back 200 years. They cited Marbury versus Madison, 1803 U.S. Supreme Court case. So they are getting ready to jack somebody up, and they're laying the foundation for it. This is called the predicate. So she either shows up or they're going to jack her up.
Okay. Yeah, because he keeps saying Mason.
Mason is that thick book. You see the red one laying to his left, screen right.
Yeah.
It was propounded by a gentleman named Mason, pursuant to the California legislative body requesting that. And that was years ago. That modified the previous one that had been used by most state and federal legislative bodies to conduct their action, which was based on something that Thomas Jefferson penned to help out the original legislative body, the Congress, the Senate, and the House, way back when. So he's laying it out so based on parliamentary or legislative procedure, everything they're doing is in order. And what you had the last witness, the attorney for the committee, doing was laying out the case law and the legislative statutes that enabled what they can and seem about to do if she does not show up.
Okay.
So they're laying the case for bringing out the headsman with the axe.
Plainly the subject on which legislation could be had and would be materially aided by the information which the investigation was calculated to elicit, end quote. The U.S. Supreme Court in Watkins versus U.S. said that Congress's power to investigate is at its peak when the subject is the alleged waste, fraud, abuse, or maladministration within a government department. That's Watkins versus the U.S. 1957 case. So the subject matter, I think, of this
that was very
important
right there, and that's very damning to Fani Willis, misappropriation, misuse of publicly appropriated funds, and that's what they're talking about.
Conducting an
they're going to stomp her
herein. The committee shall have the power to administer oaths, to call any party to testify under oath at such investigations, to require the attendance of witnesses, production of documents, books, records, and papers, and to take the deposition of witnesses. The resolution goes on further and says, for such purposes, the committee is authorized to issue subpoenas for any witness or to compel the production of books, papers, and records, and is further authorized to undertake such actions as may be necessary to enforce such subpoenas in case of refusal to obey. So I don't think there's any question at all that there's been a full grant of the Senate's inherent power to this committee to investigate and to do whatever it deems necessary and proper to compel the production of testimony and documents. Further, SR 465 specifically grants the committee the authority to meet at such places and times as it may be necessary or convenient to fully exercise and effectively use its powers to perform its duties and accomplish the objectives of the purposes of this resolution. It's line 82 of the resolution. I think this language, as we touched on earlier, is broad enough to include the authority to meet during the interim, which is specifically authorized by the Georgia Constitution. Finally, SR 465
What they're
specifically
doing
authorizes the committee the
right
power to
here
enforce
is
its subpoenas.
the legislature is not in general session, so they are legitimizing this committee meeting. And what they did is lay out another layer on the predicate or the foundation, which social media doesn't understand. They could have just jumped right to what he got through saying about 20 seconds ago, but they laid the predicate for it. So it's step by step.
Just a little bit. There's a little bit of a nuance there. I think there are three areas or three methods by which the Senate, and by virtue of its delegation, this committee can enforce its subpoena powers. And the first is by contempt. And that is set out in the Georgia Constitution. And there are some Article 3, Section 4, Paragraph 8. I think there's some limitation in that constitutional provision when you're trying to enforce a subpoena by virtue of the contempt power that's set out. There are different ways to enforce subpoenas, but the contempt power is one. And I think the contempt power can only be used during a legislative session. And it gets into the nature of how does a legislative body use its inherent contempt power. They get the sergeant at arms and they issue an arrest warrant, and the sergeant at arms, which has been in some of the cases and some of the very first uses of the contempt power of a legislative body, they go and arrest. I think the first one was maybe the Secretary of Agriculture, and they arrested him and brought him before the bar of the Senate, tried him and held him in contempt and imprisoned him. But that power to enforce the testimony through contempt is for punishment. And that power of punishment only lasts as long as the session, as we are in session. So once we adjourn sine die, we lose the power to punish for contempt. But there are two other ways to enforce subpoena powers. The second method is through a judicial enforcement of subpoena powers. And I think there's no question, Stuart can talk more about this better than I can, but if the Georgia Senate has the inherent power to do investigations and the inherent power to get witnesses and testimony and information in order to fully inform its legislative process, and that process is stymied or objected to or thwarted in any way, I think the Senate, and by virtue of delegation of its power, this committee can walk over to the Superior Court of Fulton County, seek an injunction in equity. Stuart touched on it, try to seek a declaratory judgment action and an injunction in order to enforce what is its inherent investigatory and subpoena powers. That's called judicial enforcement. So I would say that is the second manner of enforcing a subpoena. And the third manner is by statute. And Stuart laid out what we have is in the statute 45, 15, 17, and 19. I guess the only comment I would have there's this statute, there's a statute that authorizes the ethics committee to enforce subpoenas, et cetera. But the inherent power of the Senate and its ability to delegate that power to a committee is constitutional. I don't think anybody would disagree with that. And clearly statutes cannot overturn what is a constitutional power. So I think anytime you're reading a statute where it says the General Assembly, et cetera, that has to be interpreted as supplemental to what are inherent constitutional authorities of the Senate and of this committee. So those statutes, I think, should be viewed as supplementing what the Senate's powers are, not as restrictive of it. So those are my prepared comments today. I'm happy to try to answer any questions that you might have on this. And
One remark
to
here,
hear
by
from
the
counsel on
time
anything that I might have.
these matters go through application to a court of competent jurisdiction, the legislative body will be back in session, which in that case would allow the sergeant at arms remedy to kick in.
Yes.
Well, Sergeant at Arms, what is that?
He just got through explaining it. If there is a refusal to comply with the subpoenas, the Senate may authorize as a body the sergeant at arms to go physically arrest the individual and bring them forcibly, if necessary, before the legislative body.
And even the enforcement.
So they can cuff her up and bring her if she doesn't. But they have to be in session, which they are not now. But by the time they get through going through the other remedies, they will be back in session. So before then, you can go to court, and the court, if it finds that she has to comply and she does not, she'll be held in contempt, which means that the court can order her arrested, detained, confined for a period of time, or can hold her arrested until she complies.
And that's probably why she didn't show up, because they're not in session.
Well, yeah, but this
they're not in
Superior Court, but
that.
see, I know, but the second, no, I'm talking about two things. The first one, they just stick the sergeant at arms on her, and he goes out and physically arrests her and brings her back in custody. Now, the second remedy is applying to the courts. You've got 3 judges in Fulton County that recused themselves from other matters dealing with the Trump case. But this matter, one of them might hear it, or they can go outside Fulton County if all the judges recuse themselves. If a judge says you have to comply and she does not, the judge can issue an arrest warrant and set as a condition for release that prior to being detained and incarcerated, the individual comply with the subpoena, or they do and take steps to make compliance to be let out, or they can hold them in indefinitely until they comply, or they can designate a specific sentence as a penalty for failure to comply. That's what happened to that young man who was the lawyer on the rap case, who got 20 days in jail for failing to comply with the court's order, which he properly claimed he should not comply with due to attorney-client.
Of our committee rules that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move for that. I recognize Senator Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
So they're done.
No, they're not. They're just having a brief meeting. Let's talk about it. This is attorney-client privilege. The public is not entitled to be privy to this, and all we are going to talk about is, in the instant case, since we've heard about the general law, what is your opinion about its application to right now? What can we do to Fani Willis in particular?
So are they coming back on camera or are they?
They're coming back into session as soon as they have their private discussion. In other words, they're going to ask him, look, if we do this, what are our liabilities? Do we have firm grounds to bust her behind if she doesn't show up today? What can we immediately do? How do we get from the point if she does not show, how do we get it into the circuit court?
Do they contact her? Do you think they're going to contact her in that meeting right now?
No, they're not going to contact her. They're just discussing how they filed the action for contempt or for, compelling her to comply with the subpoena. They're going to ask how to do that, who is going to draw that up, how long will it take, et cetera, et cetera. See, this is Friday. The weekend is here. So what is going to be the dynamic and what are the liabilities, et cetera, et cetera? And they're going to get to the point of what do we do right now if she doesn't show? They talked about the law, but now you're talking about the particular application. In other words, if I told you as your lawyer, in a public session, what the contract law was relative to this kind of agreement you might have with the city, then you confer with me privately and say, okay, that's the law relative to dealing with the city. What about me? What do I do right now? And then that's privacy. So that's what they're doing.
Columbus says, Judge Joe Brown, the fact is this body has absolutely no jurisdiction or authority over Fani Willis.
Oh, what have you been listening to?
So
that's what they've been laid out. They didn't stop. They have been talking about it. It's ironclad. I told you that last night.
They're not live right now. They're not live anymore.
They have not stopped, and they have plenty of jurisdiction. It goes back a couple of 100 years. They have absolute authority. Every Supreme Court case, every case that's come up in Georgia, the legislative body has the absolute authority to issue subpoenas to compel production and testimony of witnesses and records so that it can exercise its authority to allocate public funds for projects and legislation. And in particular, they've already discussed this when it comes to misappropriation or misuse of public funds. They have an even stronger authority. There is no doubt that they have the authority to act. What they're doing right now is getting advice on what particular course counsel advises that they take out of the several options that they have.
Brian says Fani Willis is an attorney, which is an officer of the court. And Kane says, disagree, Judge Joe. They said nothing about being BROEF. I don't know what the fuck that means. They did vote to be private until they decide to enforce subpoena.
That's not what they're doing. They're just getting advisement from counsel about certain particular things that is their right to keep confidential.
Okay, so
And look, don't argue with me on this.
no,
I've been doing
listen.
this.
Somebody else.
I'm
listen,
talking about not you. I'm
I
talking
know,
about the
I know.
person
But
here.
let me read this. Because I'm like, are you listening? Are we not listening right? Because Sabrina says, Dana, they said she didn't have to attend as this hearing will move fast.
It's
What?
not what they said.
That's not
Nobody
what
said
she
that.
She got a
Your
fucking
cognitive,
subpoena.
go back and polish up your cognitive skills and your comprehensive assessment of what went on. That's not what they said.
Yeah, they're not going to subpoena you and then turn around and say you don't have to attend.
That's not what they're doing. They're getting ready to unload on her ass really badly. And what they did is they laid out for the record carefully. They brought in all of the case law, the legislative acts, and they brought in the traditions. They brought in the rules of legislative proceedings and other considerations. If she does not show before they adjourn, they're going to jack her ass up good. And
So,
what they're probably talking about is the mechanics of bringing this before a circuit court in Georgia and getting a court to compel her to either comply or perhaps go to jail. And if she refuses to do that, since she took an oath upon assuming office to uphold the Georgia state constitution, the Constitution of the United States of America, and the Georgia laws, she will have violated the law, which is absolute grounds for impeachment and removing her from office and potentially jailing her if she violates a criminal aspect of those statutes.
hold on for a second. Yoli, you dumb fuck. And it's Friday. He's not telling me to polish up on my skills. He's telling the other idiot up here to polish up on their skills because I'm not disagreeing with him. He's talking to fucking Sabrina, you dumbass.
I'm not talking to Miss Dana. I don't know who the
And that's
person's name was that
why
posted the
he says
comment.
brush up on your cognitive skills. Listen, think before you type, before you say
That
anything.
now applies to you, son. You should check out what happens. Remember in high school? Well, I guess they don't do it now. Class, what was the author's meaning when he said so-and-so? Or they test you on that when they give you a reading assignment and you have an essay exam. What did the person say? What was going on? That's what
All right,
we
so
heard
listen.
here. Clear,
So
absolute, nope. It's a
listen,
slam dunk.
let me read this. So Kane keeps disagreeing and saying they did vote to be private until they decide to enforce a subpoena, aka issue an arrest warrant for violating.
That's not what they are doing. They're merely consulting with counsel to get clarity on what they can do, get recommendations on potential actions that they can take. That's what lawyers do. I've done what this guy's done
And now
before.
Yoli, the dummy, is saying many attorneys do not get thrown in jail. There are no exceptions for certain applications.
That's crap. I did 5 days because I told a dumb shit what he was about when they were trying to railroad a black woman that they had no jurisdiction over. I wound up winning the case, but I got 5 days because I wouldn't back down. This young man that ought to be hired by anybody in Fulton County needing a good lawyer that's representing some of the artists on this rap case that the judge gave 20 days because he refused to reveal his sources is standing his ground, so to speak. But that's the authority of the court. So what they're going to do is, since the general body is not in session, so they cannot just order the sergeant at arms to go put Fani under arrest, handcuff her, and bring her back forcibly if necessary. They will have a second option, which is to go to a circuit court and make application to have the subpoenas enforced, which if she declines to comply with, she can be locked up for contempt. The third option is, since they are the state legislative body, they can pass legislation that defunds her office also sets up a special act of the state legislative body directed at her. They can do that. They have 1, 2, 3 options: sergeant at arms, go to a circuit court, or pass legislation. So all they're doing is discussing with their attorney what he thinks happens to be the best option. And each of them may have some individual considerations that he wants explored. That's all they're doing. They took a temporary recess. They adjourned the public meeting. They are continuing as a committee in a private session. And as soon as they finish, they will reconvene with the public session. That's all they're doing. It's in that thing that you were looking at the last witnesses left, that red book. And it's also subject to being called parliamentary procedure. So that's Mason's. It's a thick book that has been added to over the last 80, 70, 80 years. So there you go. Nobody has said they don't have any jurisdiction. And what you're looking at from having participated in this kind of thing often enough is they're getting ready to kick her ass good if she does not comply.
Right. And also it's a disrespect to the law which you were elected to uphold. You know what I'm saying? So
she said it herself, no one's above the law, so how does she get to be above the law? Oh, I know, she's black female and they're dumping on her. But you see, as I've said on this forum many times, she answers to no one generally but her voters. But when you start messing with the state's money, they have a right to see what they did with what you did with the tax dollars that belong to the people of the state of Georgia. That's long been established. And if you want to get into it by analogy, and Georgia's rules are pretty similar to the U.S. Congress, House and Senate, is one has only to review the hearings they had on the mafia, organized crime, which led to the RICO doctrines of 1970 when the first RICO statute was passed by the U.S. Congress. And you can talk about the red communist hearings they had back in the 50s with communist infiltration, the mob influence. They do this all the time. Legislative bodies often do it. Where is our money going? What should we spend our money on? Is this a worthwhile investment for the state? How much money should we allow the district attorneys to control? So now they've looked at what Fani brought out with Wade when she appropriated $720,000 of tax money to him for basically doing nothing. And they are concerned about that. Also, there are issues with $7.5 million that was appropriated specifically to her control that dealt with eliminating a backlog on the prosecution of criminal cases, $2 million that was appropriated directly to her to deal with sex crime prosecution, which seems to have disappeared, as has the $7.5 million, and another $500,000 specifically allocated to her to deal with juvenile criminal matters that also seems to have disappeared. So that's $10 million that's gone up in the air that the legislative body certainly has the intrinsic obligation to investigate. So that's what they're doing.
right.
Now, all you're doing is a procedure. By the way, this is the way the real world works. It's not 15, 20-second, 30-second soundbite BS that makes it comfortable. You have to pay attention. You have to be able to focus. You can't talk about lack of attention span. That's what you get put in a legislative body to do. Most of what a legislator does is boring to most people. And also, I mentioned this earlier, you see a good argument against term limits because when you limit out a legislator, have utilities, fresh new bodies, but the fresh new bodies come in and there's little continuity from one generation to another, and they do not understand such things as you saw talked about for the last, what is it, hour, two, almost hour and a half. So these things build up. Somebody's been on in a legislative body. If they've been effective 10, 15, 20, 25 years, they too become expert in such things. And you'll notice the number of lawyers in this body that seem to be of red persuasion versus the ones who are not, who are of blue persuasion. So,
Well, Fani Willis' attorney, former Governor Roy Barnes, told the Atlanta Journal-Constitution that Willis will not appear until there has been a judicial determination of the validity of the subpoena. Well, they just laid out the validity of it.
yeah, they did, and they're going to go to circuit court, and she'll be assessed court cost, which will have to be paid by the taxpayers, and she'll shift it over, and she won't pay it out of her own pocket. And
So,
frankly, as I said, when she walked her butt up in there in that orange, pink, red dress on backwards, upside down, and the wrong underwear on under it, and said, I decided I'm going to testify, hand on hip, doing that snake charm thing with her head. I said, this is a bad move. You ought to understand the implications of the Fifth Amendment, but no, you're going to run your mouth. And this is another thing. It's stage by stage. That was several months ago. Now look where we are right now. And what she's doing at this point indicates an intransigence, which might not kick in until she gets sentenced for some wrongdoing, or they have impeachment proceedings to remove her from office for failing to comply with the law she swore to uphold. So, as she said, no one's above the law.
So Republican State Senator Bill Cowsert, the chairman of the committee, said at the beginning of the hearing, we have subpoenaed Fani Willis to testify. She is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting, which she did not.
That's where we are, and it's in her hands. I mean, I'm not, the governor may have been the governor, the ex-governor that's representing her, but that doesn't mean he was a good criminal lawyer or civil one either. It just means he went to law school at one time, passed the bar, but that doesn't mean you're good. There are a lot of hack lawyers going around, and some of them have national fame, but they've never tried a case, and their knowledge of the law is rudimentary and not necessarily as expert as you would expect. So you take your chances, and yes, she can appeal to a court, but what is it? It's like, why are you dragging your feet? Now, this is also not only just confined to a courtroom or a legislative chamber. This is also a matter of people having confidence in their elected officials. So the question comes up, which is asked all the time with criminal cases, but under our law, the Fifth Amendment in a specific instance, you do not have to explain to anyone when you're criminally prosecuted what you're doing, but when you're trying to maintain an elected office, you certainly do. So the question is, if everything is above board, why don't you just get a few of your staff clericals to prepare the documents or pull the documents and supply them to the legislative body? What are you hiding? This is politics here, not just what happens in a courtroom or a legislative chamber. What are you hiding, and why are you trying to avoid disclosing what you've done?
Cowsert previously said it was not within the committee's authority to seek to disqualify Willis from election case or to criminally prosecute her, but rather to investigate many of these troubling allegations. The Georgia Court of Appeals paused the election interference case in June, pending the resolution of a court battle over Willis being allowed to remain on the case. Oral arguments in that matter are currently scheduled for December 5th, a month after the presidential election.
That's
So
right.
the arguments for whether Willis would be allowed to remain on the case is December 5th, not the Georgia election case against Trump.
Yes,
So that case is not going to be tried this year, if ever.
And Judge McAfee just dismissed 3 more charges.
So this Georgia Senate committee is just investigating the many troubling allegations, such as the mishandling of funds, correct?
Yes.
And her relationship with Nathan Wade.
Not her relationship with Nathan Wade, how she came to have the state pay out $720,000 to Nathan Wade, and whether or not she split some of that money with him is a kickback, which is what the implication was, the deep implication about all of the cash transactions that they were engaging in without receipts. Also, failure to report under Georgia election laws, which goes to her personally. And does that have any place in the bigger picture?
Right, which is what, okay, so they're investigating it. Come on, you made me forget what I was about to say.
They're investigating the whole big picture, misapplication or misappropriation of public funds. There's at least $10 million that's unaccounted for.
Let me ask this question. Once they finish the investigation, and if they find probable cause of her engaging in that, then what do they do with that evidence?
They recommend to the Attorney General of the state that criminal charges be brought against her, or in this case, that the Supreme Court appoint a special prosecutor to bring charges against Fani in Fulton County. Since nobody in Fulton County is going to do this, and there is no active Attorney General there, the state Supreme Court would have to appoint someone to stand in and fill that function. A special prosecutor, which is what Wade was supposed to be relative to the Trump, etc. case. So that is going to be interesting, but it could come to that. And also, since federal funds were included in that, that could bring the government in, the United States government. And depending upon who's in the White House, it might be very troubling.
All right, wasn't she subpoenaed to go in front of Congress, or that didn't come down yet?
That hasn't come down yet. I'm sure that will happen because outside of the election situation, a lot of people are interested in why the Biden-Harris administration, with both of those two being present, had Fani Willis, had Letitia James, had Bragg, and Smith down out of Florida all attend the same set of meetings in the White House to discuss what they were doing. That looks like a conspiracy to abuse the criminal process for the specific purpose of election interference. No, I mean, the question is, why did she show up in the White House?
One second.
That's what the Congress would do.
1 second. Republicans threatened to hold Fani Willis in contempt because the House Judiciary Committee Chairman Jim Jordan sent a letter to Fulton County District Attorney Fani Willis threatening to begin contempt of Congress proceedings for Willis' failure to comply with the committee's subpoena and document request. The committee issued a subpoena February 2nd, 2024, after several attempts to obtain voluntary compliance.
Yeah, well, that's just what I said.
Let me finish. They did subpoena her, and she ignored that subpoena.
But they haven't had a hearing yet. So that's a letter from the chairman. That's all that is.
Let me finish. They just haven't held her in contempt. It's like if they have it on hold. Now she has this second subpoena from the state of Georgia, which she is ignoring as well. So it's 2 subpoenas from the federal and from the state.
Yeah, but what I said was they haven't had any hearings or proceedings in front of the U.S. Congress. So
not yet.
Yeah, well, that's the point. They haven't had them. This is an actual proceeding that's going on today.
Right. So the state proceeding is happening today, which she ignored. And then now, if Congress, they're back in session. Yeah, they're back in session. If Jim Jordan and that House Judiciary Committee have a session on her, and she
They
may end up,
can issue a contempt finding.
right. Well, they did they? Yeah, they helped. Wait, no.
There's a letter sent to
Oh, they
her
was
as
they
a
didn't held her
courtesy.
in contempt. They was threatening to.
Yes, that's a courtesy letter that was issued to her. I took that into consideration, saying, show up, show the documents, produce the documents, or we will proceed on contempt proceedings, which means you get brought into federal court where nobody is answerable to voters in your district.
So before we end for the day, right? Because it's noontime here. Why do this bitch think she can ignore 2 subpoenas from your state Senate committee and from Congress? Because she knows she is protected.
She's not protected. She just has an arrogant, narcissistic view of her position in the world, as does Letitia James in New York, as does Bragg in New York, as does Smith down in Florida. It is a common failing of prosecutorial entities. They think they are above it, and that's the same problem that you have with Kamala Harris Imhoff. She displays the same thing. What you see right now is what went
When I
on in
say she's
California.
protected,
So this is a
saying,
repeat.
but I'm saying when I say she's protected, I think the Biden administration is protecting her with the
Well, they
delay.
can't protect her in the Georgia thing, and there is this thing they just got through discussing, the separation of powers. The executive, the legislative, and the judicial, neither can intrude on the other. So no matter what the Biden administration does, the only way it can interfere with what Congress is doing is generate sufficient influence in the members of the concerned Democratic Party within the Senate representatives of that party, or a sufficient number in the House to combine with Republican members to stop it, but they can do what they want to do.
Mm-hmm.
And if the president, the executive, refuses to enforce it, they can go to court. And if he denies what the court orders him to do, then what happens is he's subject to impeachment by the legislative body. And if convicted, he can be removed. Now, anybody complicit with that, that goes, interestingly enough, under Article 2, Section 4 of the Constitution. That goes to the president and the vice president jointly. That might be very interesting. And as the precedent has been set by the Republican-dominated House, or at least at the time when they did it, they proceeded against Trump for the second time when he was no longer holding the office, according to them. So it wouldn't stop just because they're out of office, and Miss Harris, Mrs. Imhoff, might be permanently removed from the picture based on what would come out of those things. So there are long-term consequences, and people quit thinking in terms of next Monday or next month. You have to look in the future to see the consequences.
So, last question. If Kamala Harris is elected president, can her being president help Fani Willis out in Georgia?
She can't issue a pardon for a state offense. She might just order the Attorney General's office and its representative, the U.S. attorneys for various districts, to stand down and not proceed any further, which they might or might not obey. They don't have to.
Well, how about unofficially? So you get.
Well, she can talk, but what kind of influence to someone who is only recently on the national scene? For when did she get elected to the Senate? 6 years ago? Yeah, about 6 years ago. So I don't think that's really enough time to get sufficient influence around the nation to have much to do with that. So
Oh, well,
that's one of the problems. She's not really into what's going on. And for that matter, neither has Trump been, but Trump has been one of those shadowy figures behind many thrones with the money he's donated, and he probably knows where the skeletons are in which closets, and hell, where the graveyards are.
yeah. So how does this hurt her running for re-election for DA, Fani Willis?
Well, it ought to, but apparently it won't, because everybody's going to assume she's sister girl getting dumped on by white supremacy rather than just arrogantly, narcissistically stupid and criminal, for that matter. See, what we've talked about and what we've investigated, we've discovered that corruption in Fulton County from high to low is rife and rampant. They arrogantly think they can get away with everything because they control the politics in Fulton County, meaning the blue black folk or blue Negroes. So they have been effectively carrying out something I'm familiar with, which is the protestation of it's our turn to get the gravy now. Yeah, but it's your turn to show honesty in government, not use the opportunity to steal from the people who are still not getting anything. See, Fulton County is majority black, and it is what it is. So I just ran into them last month. I was down there. We had a little together thing out at Liberty Arena, Liberty Park, or whatever they call it, right across the street from the courthouse. And Miss Fanny sent word down there trying to get us to be quiet because some of the people were talking about her, and everybody was talking about Harris not too well. So that's that kind of interference with the First Amendment, which seems to be rife, and it seems to be totalitarian in its slant and bent, and if not being polite about it, it's Nazi-esque, it's fascism, and that's what we have here. You have a group in power and an authority, and they're using it for self-enrichment. Is this famous mayor over here on the far right that just spent $85,000 on a party that had less than 100 people there so she could entertain and brag about herself? No, I'm not talking about Wade. I'm talking about the woman. Who is that with the blonde hair? Is that Fanny?
That's Ashley Ashley Merchant.
Yeah.
Boy, I call her Merchant of Death because she's that.
Okay, all right. That's not the one I was thinking about. I can't see it. It's kind of small over there.
Yeah.
Okay.
Right.
She's holding everybody's feet to the fire.
Exactly. Anything else you want to say before we get up out of here?
Well, I wouldn't leave because I have a sneaking suspicion it won't be long before they come back in session.
No, they're not coming back in session.
Yeah, they are. He announced it. It says we are adjourning the public meeting. The committee will still be in session discussing privately. And when we complete
they're not going to show it publicly.
Yeah, but what he said was, as soon as we complete that, we will reconvene the public meeting.
I didn't hear him say that.
I did. So anyway, the point is, when are they going to reconvene? I don't think it'll be too long before they just, can we do this? You know what we're thinking, can we do this? And they won't be as formal as they were when you heard them. Can we do this? Okay, how are we going to do it? What is the prospect of somebody in Fulton County doing this? Are we likely to wind up with the Supreme Court appointing a special prosecutor? Who is that going to be? Those are the kinds of questions that they're going to ask the lawyer.
Judge, they're done. They're done. They're not coming back.
I bet you they do.
Not today. They're not.
I bet you they're going to come back today because you know why? You know why they're going to come back today? They have to. You know why they have to? because if they adjourn till tomorrow, there is no session tomorrow. That gives Fani until Monday an opportunity to think about it and show up early Monday morning. They want to trap her into contemptuous behavior, so they have the ammunition of saying, you broke the law, we can proceed with impeachment proceedings. We can also get you immediately in front of a circuit court. So if they
I'm about to
adjourn
play it
totally,
again. Wait, hold on for a second. Hold on, because I'm about to play it again.
Power, and
with our counsel to let us know that we have hired Mr. Josh Belafonte to assist us in our legal enforcement efforts on the subpoena. And I would like for us to have an opportunity to be briefed by him. We have privileged communications with him under the attorney-client privilege. Our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move for that. I recognize Senator Kennedy.
thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
they're not through. That's just a
I know,
technicality
Judge.
under the rules.
They,
Under the rules,
Judge, stop.
Yeah.
He said they are adjourned for the public, but they're in an executive meeting, so they're not coming back to us.
But did you hear the word sine?
Yeah, but
No,
they're
you
still
you
meeting.
didn't. No, parliamentary procedure. That isn't even on Mason stuff. That's before that.
No,
If
that's
they
fine. No. I'm
listen. If they had adjourned just generally, they would have said, we adjourned sine die. All they did was adjourn to continue in a closed meeting, which means all they have to do when they end the closed meeting is call this assembly back to order and
They're not going to come back on camera.
I want to bet you they will. You know
All right, well, I'm
why?
not staying
Wait a minute. No, I didn't say you had to, but I just said they're not through because of this practical consideration. They issued a subpoena to her to show up in front of them. If they adjourn before they deal with that business, then the subpoena says you have to appear in front of the convened committee, which means she's got the whole weekend free. They can't do anything to her. If they come back in before the close of business today and they reconvene and she does not show up, then they can institute proceedings to compel and or have her found in contempt.
I'm not
but they have
staying
to
on
do that.
here to see if they're coming back.
You don't have to. I didn't
But
say you did.
Okay, but Judge, what I'm saying is right now, they're not live streaming to the public. They're behind closed doors. They may or they may not come back on. Listen, they may or they may not come back on live stream. We don't know that, but they are behind closed doors. So right now, it's done for us. We can't say.
Okay, it's done for us as entertainment factor, but the public needs to understand they're not through for the day yet.
I know.
And
I'm
what
talking
happens
about the live stream. I'm saying for me and you to say goodbye because the live stream is over. That's all I'm saying.
Okay, the live stream's over, ladies and gentlemen. We are going to duck out, but stay tuned
if they
what else is going to happen. It'll be back on.
if we get a notification or if the news people say, oh, they're coming back today on a Friday and it's already 12 noon, I doubt it. But if they go live streaming again, that means maybe somebody else is speaking. Okay, fine, we'll go back live. But right now, there's no more. They're not live streaming to the public. They're behind closed doors.
Well, let me say this about the Georgia legislature as it applies to Tennessee, Arkansas, Alabama, U.S. Congress. Oftentimes they are in session at 11 o'clock at night, 2 a.m. in the morning, and the only stricture, as I understand it, that applies to Georgia, Tennessee, and the southern states is at midnight Saturday, you cannot proceed in a couple of these states on Sunday. But other than that, any other day in the week, you can go 24/7. That's when somebody in the Senate for either a state or the U.S. Congress wants to filibuster. They will go for several days nonstop. People go to sleep at their desk or walk out, take a nap, come back, and that person is still going. So the legislative body is not bound by an 8-hour day. That's unless they choose to be. So anyway, pay attention. It may be back in session, but I think they're going to spring their trap because they're going to come back in session before the business day is up. Come back in public session where they have to have such hearings before the business day is up. And if she's not there, they're going to pass a motion, introduce a motion to proceed further through the action that they can take as a committee. Now, that's what I predict is going to happen. They've laid the trap. So you might as well bust her.
If they come back live stream, it must be something, and we'll just come back live. But we're signing out for now.
Yeah.
Everybody have a good day.
In other words, they got to open the trap back up to let her. In this case, the trap is sprung if she doesn't show up. So anyway.
But either way, it's not over.
No, it ain't over.
No. All right. See y'all later. Bye. Oh, shout out to everybody on X. Y'all listening heavy. So hello, everybody on X. All right, bye.
Okay, ciao.
Enjoy your day.